Very good morning, everyone. Just 2 minutes will begin. Just 2 minutes will begin. Very good morning, everyone. So today in this session, we are going to do a marathon concept revision of three very important areas. One, interpretation of statutes. Two, LLP. And three will be FEMA. In this, first one is interpretation of statutes. With regard to the interpretation of statutes area, there are so many concepts. Students often feeling allergic to this chapter, but coming for 13 to 14 marks in every examination, minimum 12 marks will come, maximum is going up to 14 marks. So in the light of given for so many marks in examination, I think there is no common sense in leaving this particular chapter. So let us start with the concept relating to interpretation of statutes. So let us first have a look into it. Okay. Interpretation of statutes, we are going to start by covering out each and every concept. But the advantage of this chapter, interpretation of statutes, is there can be no great question that can be asked. Direct questions will come. Means they will ask you clearly, what do you mean by rule of harmonious construction, rule of reasonable construction, rule of beneficial construction, explain the Heydon's rule and when it can be used. Clear. Last attempt there is a question came that what do you mean by rule of ejus dem generis, like that. Direct questions will come. Here and there small technical questions will come, but those are also very easy. So first what we need to do is, let us cover the chapter as it is. Okay, then we will be going into the idea behind how the exam questions are being tested. Okay, first I will show you the exam questions also for you to have a clarity. Just a minute. Okay, see here. So what is the name of the chapter? Interpretation of statutes. 10 to 14 marks is the weightage for this chapter. Okay, see, first one. In this, so many questions are getting repeated every attempt. How many questions I have compiled? I have compiled around 60 questions in this chapter. In these 60 questions, at least 30 questions are repeated. Means what? Same question repeated again and again. The chapter has 14 concepts. Okay, 14 concepts they have to ask in every attempt, and one among or two questions out of every 14. So every attempt there will be a repetition from this chapter. You can't expect a new question to come from the interpretation. That's the greatest advantage of this chapter. So in this chapter, nonsense will be very less. What we read is what we get in the exam. Understood? So when chapters are like that, a fool only will leave these kind of chapters, because there is a scope and boundary restrictions for a chapter. These only can come. For example, if I talk about a chapter like share capital, general meeting, etc., there is a chance that they can ask a twisted question in exam. Though you can do after doing a good revision, but still there is a chance that, okay, I can understand the question or not in examination hall, or share capital chapter, will I remember all the contents or not? Like this, so many things will hit the mind. But that problem do not come in case of interpretation of statutes. Read properly, they will only come in examination. Are you clear to the point? Shall we begin? Everyone, shall we begin? Yeah. See here. Okay. See, one by one, let us understand. Repeated question, whenever it comes, we will put R. Means it's a repetition. We need not read it. Okay. First, let us start with the concept. Number one. See, so many times a question got already tested in exam. Let us first to do that. Explain how dictionary definitions can be of great help in interpreting or constructing an act when a statute is ambiguous. When a statute is ambiguous. What definition? Dictionary definitions. Okay, see here. I will first tell you the idea behind this question. Thereafter, we will read. See, whenever we read the act, and whenever there is a technical word that comes within the act, okay, any technical word that comes in the act, first that word or expression will be defined in the act itself. Defined in the act itself. So first thing, wherever there is a technical term or a technical expression or a word, it will be defined in it. In it means in the act itself. If you could not find the definition of a particular term within the act itself, then we may, not we shall, we may, it's optional. Okay, if there are other ways of understanding the definition, go with it. We may refer to the dictionary, but there is a disadvantage with the dictionary meaning. whenever I define a technical term in a dictionary, first thing is dictionary la word will be defined in a general sense, not in the context of a particular section. Clear or not? For example, I will give you an example. Listen carefully. See, there is a term called as undertaking. Undertaking. There is a term. That undertaking term is used 3 times in Companies Act. Okay. One time in section 180, their explanation of one definition was given. Winding up time, 2 times they will use the word undertaking. There are different meaning they have assigned to that. Means the term undertaking means a factory undertaking, business undertaking, like that. Winding up time, different meaning they have assigned to that. From this, what we have to understand, definitions always define from the context. Define from the context. For example, there is a section. In that section, there is a technical word. They will define in the explanation. They will define in the explanation. Means what? In the context of that particular subsection or section, this is the meaning. How come dictionaries can define the meaning in the context of a section? They will give a general meaning of a term. So, point number 1. Okay, first we need to refer the act. I repeat, first we need to refer the act to find out the meaning of any particular term or expression. If we could not find a word defined in the act, then one may refer to the definitions. However, definitions will define a term in a general sense. General sense. See, definition, whenever you see the term, 4 or 5 meanings they will give. Okay, they don't just assign one meaning. They will assign 4 or 5 meanings to that. Which meaning out of it to assign in your place is entirely the discretion of the reader. Sir, I didn't understand the last one. Sir, I will give one example. At least try to understand. See here, I opened a dictionary. Let us do a search engine operation on this. Let's try to understand. Okay. See here. Undertaking. I'm clicking the same. Okay. See. 4 meanings are given. The act of a person who undertakes any task or responsibility. That is undertaking, Companies Act. A task or enterprise undertaking. That is undertaking. A promise or pledge or guarantee. That's undertaking. Business of an undertaker. Okay, undertaker, WWE undertaker. So, business of undertaker or a funeral director. That is also undertaking. Which meaning you will assign? And none of these meanings are there in Companies Act. Companies Act undertaking is defined as undertaking means an undertaking in which not less than 20% of the investment goes inside is an undertaking. If you give a dictionary meaning to that, none of these are really fit for the purpose. Did you understand the point or not, everyone? Live students. Live student, did you understand what I said? So that's the problem. Dictionary meanings you can give, no problem. But when you give dictionary meanings, like this problems will come. One meaning, one word, 4 meanings they have given. Are you understanding? One word, 4 meanings they have given. Sorry. 4 meanings, none of them are fit for our purpose here. So what you will do? Sorry, we are looking at a particular definition. We found 4 words. In that, which one should be selected for your purpose while reading that section is at the discretion of the reader. Okay, if he takes the first one, then he is giving a wrong meaning for the term undertaking. Understood the point clearly? So therefore, dictionary meanings can we take or not? Let us practically understand. First step number 1, find out the meaning of the term. Find out the meaning of the term. So therefore, refer the act itself and try to find out the meaning of that particular term or a expression. If the meaning is not defined in the act, then you can go for a dictionary. But the dictionary will always give a general meaning. Okay, in common sense, how people will understand, that only they will give. Okay, next. But whenever you search a term in dictionary, several meanings will be given to that, like what I shown you now. Because of that, what will happen? Which one to select is entirely at the discretion of the context. in the context in which you are reading, in that context you have to pick any one of the 4 or 5 or 6 whatever the dictionary has given to you. Understood the point clearly? Yeah. So always remember, the term meaning, the meaning of a particular term should not be understood generally when you are reading a law. Okay, it should be understood from the context, the color of the context, the color of the context. In the context of that particular section, undertaking means what? You have to understand that. I will give you super duper example. Listen carefully. Sale, dispose of any undertaking. Okay. Number 2, in a contract of guarantee, contract act, surety undertakes to pay for principal debtor. Undertaking. Now students should use common sense and tell. I will give you 2 scenarios. Number 1, business, factory. Okay, business, factory, or any establishment, promise, agreement, etc. Okay, for point 1, which one will fit? When you are reading point 1, the term undertaking will take color from which one? And when you are reading point 2, it will give the meaning of what? Means point 1 ki 1, point 2 ki 2, or point 1 ki 2, point 2 ki 1. Which is the correct one? See, that is common sense. That's the point I wanted to tell. Dictionary, both meanings will be given. Business establishment was given, person undertaking also given. But in the context you should read. That's what these sections, this concept say. See, if you understand like this and read, no mistakes will be committed in exam. If you read it like a paragraph answer, life never you will remember interpretation of statutes. First refer the act to find out the meaning of a particular term or expression defined. So step 1, check the act itself, summary. Step 2, not defined. Then go to the dictionary, but dictionaries will give general meaning, commonly understood. But dictionary one meaning will not be given. Multiple meanings they will give for one word. Selecting one out of several meanings. Okay, we must always consider the context in which it is used. It is the fundamental rule that meanings of the words and expressions used in an act must take their color from the context in which they appear. From the context in which they appear. Understood the point or not? From the context in which they appear. Now, question will arise, sir. Whenever a term is not defined in the act, that means we need to go to dictionary first. No. If there are any court decisions, and judicial decisions are there, first give weight, more weight to the judicial decisions. Means what? Court definitions are different from the dictionary meaning. Dictionaries will define it general term. Court will always take consideration of so many concepts and then court will define. Court definition versus the dictionary definition. Which one we should prefer? Everyone, YouTube live, answer. Court definition versus dictionary definition. Court versus dictionary. Who will win? Weight should be given to whom? I'm looking for your answers. Correct. So the main provision here is always the terms used will take color from the words that they use in a common sense. See here. So whenever a term is defined within the act, whenever a term is defined within the act, so let it be defined in the act itself and take the word. Not defined, one may refer to the dictionaries to ascertain the meaning of the term, but dictionaries will define in a general and common sense terms, selecting one meaning out of several meanings that are given in the dictionaries depending on the context. Always the terms used in the dictionary should be taken from the color of the context in which the term is used. And next one, if there are any judicial decisions, if there are any judicial decisions of a particular word defined by the court decisions, more weight must be given to that particular term which is already defined by the court decisions. See, further, judicial decisions laying down the meaning of the words in construing a statute in pari materia. Pari materia means more, what to say, weight will be given to that and will have a greater weight than meaning furnished by the dictionaries. Okay. However, for technical terms, reference may be made to technical dictionaries, not general dictionaries. Okay, means legal terms will be there, legal dictionaries will be available. Go to that legal dictionary and read the term, not normally. Understood the point? So therefore, first point, you please answer my question. Whenever question comes on dictionary definitions, you have to write 5 points in that. Everyone revise all the 5. See, I will write as a summary here. Point 1. Point 1. Whenever dictionary definitions are there, can we take? First, refer to the act to know the meaning of a term or expression. Step 1. Step 2. If the term is not defined in the act, if the term is not defined in the act, so if it is not defined in the act, then what to do? If it is not defined in the act, then we need to go to, if the term is not defined in the act, then go to dictionary. But dictionary will define in a general sense and commonly used. Okay, in a general sense and commonly used. So first refer the act for a term or expression not defined in the act. Go to dictionary. Dictionary defines in a general sense and in a commonly used expression. Several meanings will be given. Select as per context. Since words should take meaning from color of the context. Like that, some technical words you have to write in exam. Yeah? In a general English, if you write, they can't find that in the key. See, if you find anywhere that a book does not carry the language of ISM with respect to interpretation of statutes, I'm giving you guarantee you won't get the marks. You won't get the marks. Same thing, you can also read in a simplified English language. This is as it is given by the institute here. Okay, in question bank, I never changed any language. Student has to read that hard work. If you don't put what is the meaning, and shall I tell you another thing? Really put hand on your heart and tell me, really is this difficult? Everyone, really you tell me, is this difficult? This is such difficult. We can't understand, we can't read. Is it that difficult? We don't put effort. That's a problem. Problem is not about the difficulty in the context of the ISM. So we don't put any effort. When you don't put any effort, how success will come? Put the effort. Read only ISM. Nonsense books, throw it in dustbin. Understood or not? That's why in class also what I teach. Did I any time open my question bank in the class? Never I do that. Okay. I open only 2 books for you. Number 1, Bare Act. Number 2 will be ISM. Instead of reading all these, if you read any other books, I am telling you very, very clearly, you are having a stepping stone to failure. Read study material. Read Bare Act if you want. Learning Bare Act. After learning, I suggest read study material properly. Read all RTPs, MTPs. If you don't need, you have to compile RTPs. Time waste. MTPs website not available. Only one attempt by MTPs only they will put. After that they will delete. If you want, you take a question bank. Any question bank. It's not about question. Any question bank you take. But when preparation, if you are reading any book other than ISM, I am cursing you. Seriously. Why you are leaving institute? Yeah. Why you are leaving institute? FM also, you know me, na? Did I open any other book in the class other than ISM? Can't I make my book? I have my own book, do you know? For FM also, I have my own book. But never I opened that in the class. Why? It's not about Kaushik or publicity. Yeah? You should pass first. If I open my book, now automatically student will see, this book is there. Where it will be. See, so many comments will come to me in YouTube also. Where book is available, where book is. Did I reply to that? I will never reply. Because I don't encourage buying books also. Read study material properly. See, Shankar made a message. From where we can find the question bank? Can't I tell? It is in my website. Go and buy. Never I will reply to that question. Because reason is, you take anything. You take institute research. If I don't reply now, what he will do after some time? He will go to institute and read. That's the stepping stone for your success. Did you understand what I said, everyone? So be with the institute. I read institute suggested sources. Don't read any other book. Understood the point or not? So it is not about me doing something. Yeah? You should first change. Change your attitude. Change your mindset. Okay, don't just fall into the trap of people. Read study material properly. See, this answer is given by the suggested answer of institute. As it is, this is a copy of study material. Kaushik Mukesh did not prepare. Who is Kaushik Mukesh after all when compared to institute? Who is Kaushik Mukesh when compared to institute? So please listen carefully. Okay. So see, one person also made Harmonious. BOS website there has last 800 model question available, sir, applicable. See, do that. Why you are unnecessarily wasting money? Why you are wasting money? Yeah? When there is a chance now, why you are wasting money unnecessarily? And a joke. Money will come free of cost to your parents. If you spend something, there should be some value addition. Nonsense. I have seen. I don't want to mention anything. Answers in the question bank, answers in that material are not in tune with ICAI. Then how student will pass? Student will always see, okay, this is completed in 200 pages, this is completed in 100 pages. You are seeing 100 pages, 200 pages, yeah. You are not reading study material. That 100 pages, 200 pages book don't contain study material language. It contains their own language, for which you don't give marks. Take it very seriously. Okay, take it seriously. Yeah? If you read from 200 pages to 100 pages notes now, from today, you change and you change others also. Make them to read study material first. Do you understand the point or not? Don't let people to do unnecessary business with you. Do it properly. Read from study material. There are so many sources now. Institute is releasing charts. Institute is releasing RTP. Institute releasing MTP. Institute releasing study material. Everything institute is doing, you are going to a third party, means what is the meaning here? Why I am telling now, see, I saw books here. I don't want to tell any name. The point is very clearly, see, the answer they have given is not in tune with ICAI, ISM, Interpretation of Statutes chapter. Last attempt, I am taking live at Hyderabad. Okay, students are sitting in front of me, face to face, revision. Then one student opened the book. Okay, see, I am showing this material to them. This material. You are seeing now? This material I shown to them. You are seeing here whatever I have written. Okay, this one I kept there, and I'm showing this, and I'm making them to read. Okay, then one student asked, sir, your answer and my answer is not same. Completely there is a difference. Then I asked, give the notes. They are reading some material. Names irrelevant. So, hell, that answer is not in fine tune with ICA answer. Do you know what is this? You are seeing on the screen. It is copy paste of ISM. Copy paste to ISM. If you can see ISM ditto. ISM students are not reading. That's why I have made into point-wise format. Can't I sell these books by writing? CA final KFM I will write 900 pages. That is a content, understandable. Because institute material is not doing a proper justification for the subject of AFM. But internal FM is very well. If it is very good, why you need to go for any third party materials? Do you understand my point, everyone? Understood in a positive way. This is for your success only. If you don't write as per I say, how you will get the marks? Do you understand what I said, everyone? Everyone in live tell me, did I tell anything wrong? Don't you know that what I said is right? Don't you know that what I said is right? So, first point number one, if you are reading third party materials, okay, with a due respect to everyone, put that after you. First read study material. Okay, read study material. Open the ICA material first. See what is going on in the textbook. Okay, you are reading any third party material now. Do one thing. Tomorrow we will speak again about this. Open that material, see the answer, open ICA, see the answer, compare. Interpretation of statutes chapter you open. Okay, interpretation of statutes chapter you open. This book, open both ISM and some X. Open. See the dictionary meaning concept. Or you open some rule of interpretation, harmonious or something. Open. See their notes, see institute notes. Here 2 points will come. This answer, both are not same. Then throw this. This answer, both are same. Then why you need this? Throw this. Understood the point? Did you understand the point? X, ICA. X, ICA, both are not same. Throw this. X, ICA, both are same. Then why you need this? Throw this. Okay. So logical, na? Easily understandable. Read ICA material. Read ICA material. First read ICA material. If anyone say don't read ICA material, don't listen. Read ICA material first. Okay, keep in touch with ICA material. See, they changed a lot here. This is not like before. They are giving concept, they are giving examples, they are giving illustrations, they have given examples for the concept, book back questions, proper explanation was given. So do that properly. Okay, why I am telling this is, see, interpretation of statutes chapter, read study material only. That's it. There is no second thought on that. Okay, see now, whenever dictionary definitions are there, what we discuss now, first refer to the act and know about the term. If the term is not defined, take dictionary. But dictionary meanings are defined in a general sense and in a commonly used pattern. But dictionary, whenever you read, there is a problem. There are several meanings given for a term. Selection of one particular term depends on the context you are reading. Next, after that, next one. If there is any judicial meaning given to that, if court defined, see, there is a chapter in Companies Act called as chapter number 16, prevention of oppression and mismanagement. Prevention of oppression and mismanagement. There, the term oppression is not defined anywhere in the act. We will take from court case laws. There is a case law called as Shanti Prasad Jain versus Kalinga Tubes Limited. Shanti Prasad Jain versus Kalinga Tubes Limited. There is a case law happened in Supreme Court. From that Supreme Court judgment, we will take the term oppression. Did you understand my point or not? So what you have to understand, if at any time a term is not defined, go to dictionary. But if there is a judicial decision defining the term, give weight to the judicial decision only. So judicial meanings are given means it is pari materia. Like this, you have to write there in exam. Pari materia means more weight. Okay, greater weight than dictionary meaning. Write these four, you will get 4 marks in exam. That's it. Answer completed. So everyone, I'm giving 1 minute time for you. Read all the points written here. Have you done? Understood the concept, everyone? Everyone, are you confident with the concept now? Next one. So dictionary meaning we completed. Dictionary definition we completed. Next one. Okay. Next one. Mischief rule. So this is also called as Heydon's rule. Which rule? Heydon's rule. See, there are totally, directly let us go into the concept, okay? Not like in a normal regular session where in a sequence we'll go. Let's go in the sequence of the exam questions directly. Okay? See, first one, mischief rule. Let us focus on understanding this properly first. Mischief rule. See, there are totally 7 rules of, primary 7 rules of interpretation. Literal construction or literal interpretation, reasonable, harmonious, beneficial, Heydon's, exceptional, ejusdem generis. Totally how many are there? 7. Sir, why you have written on left side? Why you have written on right side? Listen. First thing, student has to understand in interpretation chapter is, there are only 2 rules of interpretation. Literal, reasonable. Literal, reasonable. Literal means giving it a grammatical meaning. Okay, direct meaning to the terms used in the act. You are reading a particular statement. There is a word came. Read the definition for that word, technical word, general word, normal English meaning you give. Giving a plain grammatical meaning to a particular section, reading it as it is without giving any second meaning to the term use is called as a literal construction. 90 out of every 100 times we read act as per literal construction only. But that 10 concept is there, not 10. Out of 100, 90 times we will do this. But at 10 times, what will happen? Sometimes giving a literal meaning to the term may disturb the idea behind the law. In that case, we will go for reasonable construction. In reasonable, there are 5 again. That's how you should understand. Reasonable construction is not a construction. Reasonable construction means when literal construction fails, give a reasonable meaning to that. That reasonable meaning will be given as per harmonious, as per beneficial, as per Heydon's rule, as per exceptional, as per judicial generis. Everybody, did you understand the idea behind the rules or not? Done. So listen, again I am telling you, take it as a warning. Other laws extremely important for exam. Okay? Other laws extremely important for exam. After live, this video will not be available on YouTube. Okay? After live, this video will not be available on YouTube. So if you want to listen, listen in live. Clear? You should have that seriousness. Okay? The class should not become a joke. So therefore, this will not be available on YouTube after the class. I'm telling you seriously. After that, don't blame me. That is entirely at your fault, not listening properly in live. Okay? So let us continue. See now. There are only 2 interpretations here. Literal, reasonable. Literal, I will discuss later. Whenever literal interpretation could not be given, then we will go for reasonable construction. Then we will go for reasonable construction. In reasonable, there are harmonious, beneficial, Heydon's, exceptional, judicial generis. All are asked in exam. So all we need to read. Let us first concentrate on Heydon's rule because they asked in exam. Let us go in that sequence. Okay. Actually, in classes, what I have to do, I would go in a sequence. Literal, reasonable, harmonious, beneficial, Heydon's, exceptional, judicial. But now that is not the point. Now. We need to directly move into the concept and complete it. Okay. See. Mischief rule. Also called as what rule? Heydon's rule. Okay. See the screen once. Study material as it is with small changes. I have already written a very good notes. See this. For that 4 marks, this is enough. This is not Kaushal Mukesh made. Institute question or institute answer made it into point-wise format. And after making it into point-wise, repeated statements I removed. Okay. So the main quality content of this area, Heydon's rule or Mischief rule, is this. Let us understand by reading the context first. Start. Everyone participate. No silence. Start. When language of a statute is so that it is possible of making 2 or more interpretations, the most firmly established rule is laid down in the Heydon's case. See, language of the statute. Statute means the Bare Act. When you are reading the Bare Act, there is a word. Language here means a word. Okay, that word doesn't just have one meaning, it have double or triple meanings to that. Double meaning means not what you are thinking. I am talking about second meaning. You can assign 2-3 meanings to the words. Then what they said, whenever the language of the statute is so that it is possible of giving 2 or more interpretations, the most firmly established means 100% believed. That's called as a firmly established. These words should come in exam. The most firmly established rule is laid down in the Heydon's case. Okay, laid down in what case here? Heydon's case. See now. Where the language used in a statute is capable of more than one interpretation, Heydon's rule is followed. Which rule is followed here? Heydon's rule is followed. Heydon's rule is also called as Mischief rule, also called as purposive construction, also called as Mischief rule. Understood the point or not? Okay. Now let us understand how to apply. How to apply. See, asal when I need to apply Heydon's case, okay, when a term is possible of giving more than one meaning, the firmly established principle is Heydon's case you need to apply. Heydon's case, all these you keep away. I will give an example for Heydon's case. This example already my students will know. 1000% you will know because I already told in the class so many times. See, there is one case law that has happened here. Okay, there is a case law that has happened. There are, I think you know this example already because this is a classic example. See, there is one young boy. He is somewhere around 18, 19. There are 4 girls. Okay, this happens in UK, London, England. So there are 4 girls and 1 boy. Okay, this one boy is staying in a PG, paying guest type, in UK, in London city. 4 girls are just opposite to him. They are also staying in a hostel type, PG type. These 4 girls started harassing this young boy whenever he is moving on the road. He is going on the road. These 4 girls are harassing him. Immediately, this boy got irritated. After multiple times they have started harassing, dragging him. What these girls have done, what this boy has done, he directly approached the court and asked for a remedy. Okay, he said that, my lord, please take some action against these nonsense. So they are harassing me. They are literally dragging me when I am walking on the street. Therefore, court has taken an act called as a Street Offenders Act in UK. Street Offenders Act. There is an act called as the Street Offenders Act. Under Street Offenders Act, they said these 4 girls who are harassing him, court has given them left and right and said that if you harass him again when he is on the street, as per the Street Offenders Act, you will be punished severely. First time, fine and warning sent. After that, what happened? Days passed. His hostel is here, their hostel is here, opposite. Now they started standing on the balcony and he is also in the balcony. They started harassing him by making a foul comments on him. This boy got hurt very much. Again, he went to the court. He filed a complaint saying that again these people started teasing me, ragging me, they're harassing me. Like that, he made a complaint. Generally, reverse will happen. Here, reverse happened. So what court has done? Court said that, are shameless idiots, you 4 girls are. Just 1 week back or 10 days back, I warned you not to do any kind of nonsense on him with regard to any harassment or ragging, which is strictly prohibited on the streets. Then immediately what these 4 girls have said, sir, as per Street Offenders Act, what you said, harassing him on the street is prohibited. On the street is prohibited. Now I am not on the street now. We are on the balcony. He is not on the street now. He is also in the balcony. From balcony to balcony, we are making comments. For that section, how it will get attracted? Understood the point or not? It is all about what? Street Offenders Act. If harassment is happening on the streets of the city, then it will apply. This is not happened on the street. Therefore, sections won't get attracted. You can't punish me under this particular act. Understood the point or not? Now, see here. Street is a problem here. Okay, street is a problem here. The word street, if you apply it as if it is a street, then the 4 girls have not done the wrong. Sometimes giving the plain meaning to the term will disturb the entire spirit of the section. In such cases, lawmaker will go beyond its literal meaning and import the meaning from the context of the makers of law. Why lawmaker has made that section? Lawmaker intention is to stop or prohibit harassment. Stop or prohibit harassment on the streets. Their street is more important. Harassment is more important. Everyone. There in that context, street is more important or harassment is important? So the intention is to stop the harassment, not the intention to do any other thing. There you should give importance to the harassment or ragging or teasing, something like that. The intention of the lawmaker is not to cover the street. Understood the point or not? See, very good, very good. Thank you very much for the answer. So their harassment should be given importance, not the street. Place is irrelevant. Act is irrelevant. Harassment is important, not the place where it is committed. Normally, ragging, other things happens on the streets. They said that. That does not mean street lone it should happen. Therefore, do you know what judge has given? Judges are very level, na? So they will come from another planet. Do you know what he has said? Sorry, you said that you are not teasing from the street. Okay, you are teasing from balcony. Correct? Now he asked a question: where you are located? She said, I am located in so and so place. Okay, in which street? She said so and so street. And your apartment also is in a street or not? That means it's also coming under Street Offenders Act. Anything that comes under the purview of street will come under Street Offenders Act. Street means you are treating it as a lane, but court define the street as anything on the street. Do you understand the point or not? So, that's it. Game over. Directed by Dr. Robert Piet. It will start. So, game over. So, what you have to understand, you should not play certain times with judges. Okay. See, idea is very clear here. You should give importance to the words in the context. Not sometimes giving literal meaning to that will disturb the entire idea behind the law. Understood the point or not? So at that times you need to go for Heydon's rule. See, mischief rule will take into consideration 4 questions. Participate. 1, 2, 3, 4. Mischief rule will consider 4 questions. Example, this only you have to write. Okay? See. What is the law before making the act? Okay? What is the, remember, serious. These 4 questions you must remember. What is the law before making the act? Okay? Or I will tell this way. What is the law before making the act? What is the mischief law has given? See, those are the questions. See, what was the law before making the act? What was the mischief that law has not provided? Here, what was the mischief that the law has given but not avoided? That's how you can write. Third question, what is the remedy provided in the act? Fourth question, reason for remedy. Sir, what is this? First, everyone, read all the 4 questions. Okay, read all the 4 questions. See here. First thing, whenever question came in examination, first you have to write where the language of the statute is possible of making 2 or more interpretations. When I say street, street has 2-3 meanings. Yeah, street, buildings on the street. Which one should be covered? Always Heydon's rule you apply. Whenever a word, a language of the word, a language used in the statute is having multiple meanings, where there is a possibility of giving multiple meanings, give such kind of words, okay, which this Heydon's rule has laid down firmly established rules which are given in the Heydon's rule. There are 4 questions that one should ask in this regard. Number 1, what is the law or what was the law before making the act? Now you will get a doubt. Sir, what is this question, sir? What was the law before making the act? Law, act, both are same, na? I mean, in law, rule, other things will be there. But what is the link? What was the law before making the act means? What is the meaning? This you have to understand. Here, in this, the word law does not mean parliamented and the act law, not that law. This law is regarding the ethics, morals, that law. General principles of law. General principles of law. See, what was the law before making the act? Means what? Generally, ethically, morally speaking, is harassment from the balcony is good? No, that was the law. Means even before the act, Street Offenders Act is made, even before Street Offenders Act is made, harassment is not good. It's not a correct moral. It's not ethical. That law. Next, what mischief Street Offenders Act could not provide? Law is made now. Okay, or simply, what is a general ethics and morals? Don't harass a person. Place is irrelevant. Harassment is not good. At home means domestic violence it will become. In the road means it will become a public harassment. Both sides it is wrong only. So, something is wrong means place don't make it correct. Na? So, therefore, what was the ethics? Law means read as morals and ethics. What was the morals and ethics before making this? Harassment is wrong. Second, what is the mischief? Law has not provided. General morals are not supported by parliament power. Na? Therefore, people use it to harass. What was the remedy Street Offenders Act has provided? Harassment is prohibited by Street Offenders Act. What is the reason for such remedy? Act came, Street Offenders Act came. What is the purpose of that act? To stop harassment, not to stop the streets. So, what is the reason for remedy? Harassment and ragging, teasing, domestic harassment, anything should not happen. That's the need for Street Offenders Act. So, now you understood now. From this, what you have to understand? The word street when used can have 2-3 meanings. Road, lane, buildings on the road. Multiple meanings I can give for the street. I can give a broader meaning. I can give a narrow meaning. Whenever there is a word like this, take it from the Heydon's rule. 4 questions. What was the law before making the act? What law has not provided for? Why the act was made? That was what is the remedy provided in the act? Stop the harassment. What is the purpose of the particular act? To stop harassment. Okay. Nameless street is there does not mean only streets are covered. Harassment is important, not the place. Okay. So, hence, court should always seek. This you have to write or else marks will not be given. Suppress the mischief. Okay. Advance the remedy. Advance means give the remedy. But use the language as it is. Suppress, advance. You have to remember these 2 words. Suppress the mischief. Mischief means nonsense. Okay. There you should not consider the street. You should consider harassment as most important thing. So suppress the mischief. Advance the remedy. Everyone understood the concept clearly? I'm talking to you, everyone. Understood? Done. So, see here now. It enables consideration of 4 matters. See, what is the study material answer? What was the law before making act? What was the mischief which law do not provide? What is the remedy provided by the act? What is the reason for the remedy? Now you tell me this answer, both are same or different? Both are same or different? Both answers are same or different? Ditto copy. I copied from ICA. I proudly tell that. Okay. So ICA answer, if you could not read now, at least read like this. Make it into small points and read. Okay. But court should always seek to suppress the mischief, advance the remedy. Sir, where is this point? Suppress the mischief and advance the remedy. Courts must adopt to suppress the mischief and advance the remedy. Courts shall always seek to suppress the mischief and advance the remedy. If you write like this, you will get the 4 marks. 4 on 4 you will get. Okay. Next. So one rule also completed. Hardly we have to read 15 questions here. Put patiently, put your mind and read. Chapter will be completed. Next concept. Grammatical interpretation, logical interpretation of a statute. Okay. See. Okay. See here once. Yeah. So next concept is principles of grammatical interpretation and principle of logical interpretation. Okay. Grammatical interpretation and logical interpretation. Before going into that, I have one question. Let us first read that and then we will come to the concept. Natural and grammatical meaning. Let us first read that. See, this is the point. See here. This is what given by ICA study material. Okay. I just wrote it in a colorful format, point-wise format. That's it. I did not do any kind of magic here. Let us see. Natural and grammatical meaning. Statute must be read as per natural, popular, okay, natural, popular and ordinary meaning. It should be construed, means understood in plain, literal and grammatical sense. I repeat one more time. Listen, I will tell the meaning also. I'm not going to just read like a robot. Listen. Whenever there is a statute means the bare act, must be read as per its natural, popular and ordinary meaning. That means whenever you are reading a section, words will come. How to give what meaning I should give? Natural meaning. Normally what we call it? Give that same meaning. Naturally, popularly, ordinarily. What you will use? Give the same meaning to that. And it should be understood in plain, literal and grammatical sense. See, like this if I tell you may not understand. That's why I will take a good example. Participate. See the screen once. Sorry, I will take a section in your syllabus. Randomly, whatever it comes. Okay. Let us take a technical section. You can understand much better. Okay. See. There is a section called as 56. Transmission of securities. Let us see. A company shall not register a transfer of securities of the company or the interest of a member in the company in the case of a company having no share capital other than the transfer between the persons both of whose names are entered as holders of beneficial interest in the records of depository unless a proper instrument of transfer in such form as may be prescribed, duly stamped, dated and executed by or on behalf of transferor and transferee and specifying the names of transferee has been delivered to the company by the transferor or transferee within a period of 60 days from the date of execution. This is what we read yesterday. Okay. Along with a certificate relating to share something they said. First, when you are reading this section, there are technical terms, there are general terms also. See, a company defined in Companies Act 2 clause 20. 2 clause 20 give its meaning. Shall not means prohibited. Register, registration. A transfer of securities. Securities represent what? Securities as defined in Companies Act of the company or the interest of a member. Interest here represents not interest percentage, not a interest percentage. Interest of a member means shareholding interest, like that, in the company, in case of a company having no share capital, other than transfer between the persons whose name is entered into beneficial interest in the records of depository. Every word is defined. Whenever section is giving a plain meaning, don't do overaction with that section. Read it in natural, popular, ordinary meaning. It should be construed in plain. It should be construed in plain, literal, and grammatical sense. Words na give a grammatical meaning. Normal content are plain and literally you read. If the plain meaning giving rise to absurdity means nonsense, repugnancy, or inconsistency, then one can go beyond the grammatical meaning and apply a logical meaning to the terms. Repeat, everyone. Statute must be read as per NPO and construed in PLG. Remember, NPO, PLG, natural, popular, ordinary meaning, construed in plain, literal, and grammatical sense. Okay? Remember again. How to read? Words must be given a meaning, or a statute must be read in its natural, popular, with and ordinary meaning, construed in plain, literal, and grammatical sense. If plain meaning of a particular section give rise to absurdity or inconsistency, then leave grammatical interpretation and go for a logical interpretation. Everybody answer, understood the point clearly or not? Everyone understood the point or not, everyone? That's it. See, same thing. If you see this exam question, this is an example. This you need not write. This you need to write in exam. Statute must be understood in their natural, ordinary, popular sense, construed in their plain, literal, and grammatical meaning. If there is an inconsistency, okay, if there is an inconsistency, or it involves absurdity, repugnancy, or inconsistency, grammatical sense must be modified or extended or abridged, only to avoid the inconvenience. So instead of reading that much difficult language, in an easy language, I have written this way. Okay, if the plain meaning is giving rise to absurd, all the institute contents I have kept here, the terms. If the plain meaning is giving rise to absurdity, repugnancy, or inconsistency, then one can go beyond the grammatical meaning. Everybody understood or not? Can I go to the next one? Can we move on to the next one? Okay, done. Sir, about this we will discuss. That's why separately there is a place where we will read. Next, what is the next concept? Harmonious construction. Which construction? Harmonious construction. Let us see. What is harmonious construction? See, the harmonious construction. Let us first understand what is this concept of harmonious construction. Whenever there are two provisions discussing about, in a general language I will tell, later we will go to ICA language. There must be two provisions. Two provisions must discuss about same subject matter. There must exist a conflict. In that, step one, try to resolve conflict and apply both the sections. Why we need to do like this? Lawmaker has written section 1. Lawmaker has written section 2. Okay. If really section 1 is good than section 2, they don't write section 2. If really section 2 is good than section 1, they don't write section 1. If they read both the section, means both the sections are having their own importance. Then who are you to exclude any one section? So 99% possible. Try to resolve any conflict and apply both the sections. Number 1. If even after reasonable efforts, in spite of putting reasonable efforts to resolve the conflict, if you could not resolve the conflict, specific section will prevail over general section. What is the specific and general? That's what we are going to discuss now. Everybody, can we continue? Everyone, shall we continue? One yes from you makes me to go further. And again, I'm telling, this video will not be available post the live. So, if you want to listen, listen live. Yeah. Now see here. First, let us read the notes, which I simplified from the study material only. Okay. See. It is a recognized rule of interpretation that expressions used in the statute must be interpreted sensibly. Sensibly means from the sense of that section and harmonizes with the object of the statute. Harmonizes with the object means it should be in line with the object of the statute. First one, it is a recognized rule of interpretation that expressions used in a statute must be interpreted sensibly, that harmonizes with the subject of the statute. Opposite to the harmony is conflict. Opposite to the harmony is the conflict. Means whenever you give a meaning to a particular term or meaning to a particular section, that should not create conflict with other sections. It should be read in line with other sections. Okay. This rule will be applied when there is a conflict between sections. That's what I have written here. There should be a conflict. So opposite to harmony is conflict. This rule will be applied when there is a conflict between the provisions. Continue. If it is possible to avoid a conflict, that's what I have written. Try to resolve the conflict, means avoid the conflict. If it is possible to avoid the conflict between two provisions on a proper construction, the court should interpret in such a way that it should bring harmony between each other. That's what I have written in a simple language. Whenever there is a conflict between two sections, first try to resolve the conflict and apply both the sections. Means what? Applying both means a friendship, harmony. Harmony is called as a friendship. Okay. So bring harmony between each other. Generally, a statute shall be read as a whole. That's what I said. If really one section is not needed, why lawmaker will write it? Therefore, if he written, there is some meaning for that section. You can't just tell that this is a waste. So apply both the sections, create harmony between each other and give the meaning in that way. Generally, statute shall be read as a whole. Every provision in the statute must be read in reference to another section and give effect to both of them. However, if it is not possible to avoid or resolve the conflict, specific rule shall prevail the general rule. First of all, you tell me, whatever I said in a general English language, same content is there or not? First confirm that. Okay, it will be there. I'm giving a promise now. I won't deviate from ICAI. That much risk I don't take. Okay, so it will be as per ICAI only. See, now this is the ICAI answer. How to write? It is a recognized rule of interpretation that expressions used in the statute must be interpreted sensibly. Sensibly means from the sense of that section that harmonizes with the object of the statute. That harmonizes with the object of the statute. Okay. Harmonizes means create friendship with the object of the statute. Opposite to the harmony is conflict. So this rule is applied when there is a conflict between provisions. So when there is a conflict between two sections, first try to avoid the conflict between both of them by making a proper construction. and adopt such way where it creates harmony between each other. Okay, generally statute must be read as a whole. Means one section and the section there will be a connection. Read both of them together. Your interpretation of a particular section should not kill another section. Okay, so if it is not possible to resolve the conflict, then specific rule should prevail over general rule. Everybody understood or not? If you say yes, sir, I have a super duper question on this, not AGM. AGM already we read in the normal session. I will give another assignment to you. You will resolve the conflict. Can we? Can we go on a practical ground and do this? Okay. I will show you one section in Companies Act which you don't know. Try to resolve the conflict. Read up to here. Okay. Read? Now why I have given time means you should first absorb the content in your mind. Okay. Absorb the content first and you should understand what he is trying to tell in subsection 1. Okay. So now you understood what he said in subsection 1. Done. So what is the summary of subsection number 1? What is the whole summary? Company should not give loan guarantee security. To whom? To director or a firm in which director is a partner, okay, a firm in which director is a partner or to relative of director or to a partner of a director. Not only our company director, but also the holding company also covered. Like this, we can understand. In a simple way, I will tell you. Directors, their relatives, his partners, firms in which he is a partner. In these four, company cannot give a loan. Strictly prohibited. Understood the point or not, everyone? Okay. Understood the point clearly? Yeah. Yes. So what you have to understand from this? So the logic is very simple. Company is prohibited in giving loans, guarantees, and securities to the directors, their partners, their relatives, and the firms in which director is a partner. These four are strictly prohibited. You cannot do that. Okay? You are not allowed to do that. This is what law has said in this. Correct? Now listen carefully. But the point is, I will show you another section to you. One 186 subsection 2. Uh, 1 second. Read this. When I gave an assignment, you will get thousand tons of knowledge once you do that. So than exam questions, my assignment questions are more important for you to understand. Read it properly. This assignment question will give you tons and tons of knowledge. Okay. Everyone, have you read? Okay. Now listen. Why I am asking you to read this is I gave you around 8 to 10 minutes time. First, observe the content properly. See what he said. No company shall advance a loan guarantee security to director, etc. So many things he said. Okay. You are reading 185. Sorry. Here what he said. Here, no company shall give any loan to a person or any body corporate exceeding 60% of a paid up capital. Means without exceeding that we can give. Did you understand the point or not? 185 section. See, I will write here. 185 section, 186 section. 185 section says that no loan to director, relative, partner. Here, loan may be given to any person, including everyone, within ceiling limit. Within what limit? Yeah, ceiling limit. 60% of paid up share capital, free reserves and securities premium, 100% of free reserves and securities premium, whichever is higher. Like that they have given. Okay. So forget about the percentages here. That's not relevant for you to understand. Remember ceiling limit means, see, I will ask a question. 185 section uses the word director, relative, partner clearly. Those people are prohibited. This section says that loan may be given to any person. See, 186 section, if you see, they use the word any person, any person he can be. Individual, HF, AOP, any person. Personal, who will come? Everyone will come in person. Understood the point or not? So therefore, what is the point here? See, whenever I say 185 section, no loan should be given to director, relative, partner. These people are also persons, but not all the persons, specified persons. Director, relative, partner. Remaining you can give 185. 186 says that loan can be given to any person within the ceiling limit. Now problem started. There are two provisions. Two provisions are discussing about same subject matter. Loan. There is a conflict. What is the conflict? Here prohibited, here okay. This is a restriction only. This is a prohibition. Both are talking same or different? Different. See, there are two provisions. Two provisions are discussing about same subject matter. There exists a conflict between both of them. Okay, first try to resolve the conflict and apply both the sections harmoniously. Both the sections should move on. Law has to be read as a whole. Statute has to be read as a whole. Okay, so both the sections must be harmoniously interpreted. And then you have to give the meaning. Okay, apply both the sections. How can I apply both? If both are restricted, I can apply both. Both are prohibited means I can apply both. One is prohibited, one is restricted. I could not harmonize both the sections. When you could not harmonize both the sections, specific section should prevail over general section. Specific section should prevail over general section. Means what? Loan, when it is given to specified persons, director, relative, partner, 185 section is specific. When it is to other than specified parties, means other than director, relative, partner, 186 is a specified section. Means if the loan is given to, director or relative or partner, in this term the person do not include director, relative, partner because already there is a specific section taking them. Therefore, whenever the term person, when you are reading in 186 section, that should not consider director, relative, partners because they are already specifically covered by 185. Understood the point or not? That means when the loans are given to director, relative, partner, 185 will override 186. Specific section prevail over general section. But when you are reading normally, 186 will override 185. You can give loan up to the ceiling limits. This is the harmonious construction. One of the classic beautiful example that we can take from Companies Act. Now your turn. Did you understand what I said or not? Okay. Like this, there are 11 kinds of sections in Companies Act where we can harmonize. There is a harmonizing section with the section number 179, subsection number 3, clause D, read with section number 180, subsection number 1, clause C. There is a section called as 179, subsection number 3, clause E, read with section number 186, subsection number 1, subsection number 2, clause C. There are so many sections where there is a harmonious interpretation between two sections in Companies Act. I have taken the easiest way to understand. Understood the point or not? So there are other interpretations also. There is a section called as 179 subsection number 3 clause D that can be read along with section 180 subsection number 1 clause C. Okay, not just whatever is coming to my mouth. I am not telling. I am telling these sections 179 3D 180 1C both are talking about borrow money. Here loans na, there borrow. See 179 subsection 3 clause D borrow. Okay, 179 subsection 3 clause D borrow. 180 subsection 1 clause C borrow. Both sides borrowing. Okay. Now assignment number 2 for you. Interpretation between 179 3D and 180 1C. How you will interpret? Let us see. 179 3. Mandatory board meeting must be conducted and board of directors has to take a decision to borrow money. Okay, directly any one director can't take a decision. All directors sitting together in a meeting, they have to take a decision. Okay. 181C, they say special resolution is required for the same borrowing. But how to read this is a question now. Okay. I will give 2 minutes time. Presence of mind. First read 179 3D. Again, for your understanding, I am repeating, telling one more time. This marathon will not be in YouTube after live. Those who are not attending live, I'm very sorry. Second one, if you are leaving and going also without a discipline, then also I'm very sorry. Have you read 179 3D? Have you read 179 3D? Okay, done. Now it's your turn. Read 181C. 181 is talking about special resolution required for borrowing. There they said only board. Now they are saying special resolution. Read C. Everyone completed reading? Done. Now let us do a great analysis of both. Okay. This marathon should not be just used to just read and go the concepts in a nonsense way. You should show some difference. Before this marathon, I know this much. After marathon, I learned this. A difference should come in your mindset, your understanding, your ability to absorb the process of interpretations. It should change. See, now I will ask you a question now. Okay, you will tell the answer. I will not tell any answer. 179 3D, 180 1C. To have a harmonious interpretation, I can't fight with me, na? Okay, so therefore, antarmadhanam can happen. But technically speaking, I can't fight with me. Therefore, I should fight with some other person. Correct? So there must be minimum how many persons? There should be minimum how many persons? 2. So like that, how many sections should be there? 2. Okay, condition 1 satisfied. Okay, 2 sections must discuss about same subject or different subject. Answer. I'm looking for your answers. Same subject. Very good. Okay. Next. So both are discussing about the same subject matter. Next. Same subject matter. Now next question. Next question. There must exist a conflict. There must exist a conflict. First tell me, section 179 3D talks of borrow. What 181C is talking about? What 181C is talking about? One 3D borrow. What 181C is talking about? Eating, sleeping, jumping, reading. It is also talking about what? Hey, don't tell already borrow, excess borrow, all these. But normally you tell what is the content of 181C. Special, ordinary, ceiling limit. So forget about all those things. I am talking about subject matter. What is the subject matter of 181C? You're telling all nonsense. Already borrowed, excess borrowed. I'm not asking about how much they borrowed. Subject matter. Excess borrowing aina, already borrowed aina. It's first borrowing na. So the main content is borrow. Okay. Number 4, question for you. 179 3D requires what permission? 179 3D borrow require what permission? 179 3D borrow require what permission? Very good. Board of Directors permission. 181C require what permission? 181C require what permission? (181C) require what permission? Very good. Special resolution. Okay. I will wait till you answer. Everyone is putting the answer special resolution. I can see on the screen. Okay. Special resolution. Now listen carefully to the final touch. See, 179 3D says that if you wanted to borrow, board resolution is required. There are 2 sections, 179 3D, 181C, both talking about same subject matter, borrow. 2 points completed. There exists a conflict. One requires only board resolution, For the same borrowing, one is saying special resolution. Okay. What is the thumb rule? Step number one. Step number one is what? Whenever there are two sections discussing about same subject matter and there exists a conflict, try to resolve the conflict and apply both the sections. First, you should try that. Then, if you're not possible, then one should prevail over another. Correct? Now, tell me, 179 3D prevail over 181C or 181C prevail over 179 3D. Say, for example, 179 3D, let's call A. 181C, let's call B. A overrides B, B overrides A. A overrides B or B overrides A in this case. Who will override whom? So, yes, everyone is answering B will override A. Correct? Like this, you should not think no one will override in this case. Try to understand. Harmonize both the sections. Step 1 you have to apply, not step 2. Apply both the sections. No one will override no one. If the borrowing is within the ceiling limit, if the borrowing is within the ceiling limit, I repeat, if the borrowing is within the ceiling limit, board of directors will take a decision. If the borrowing is above the ceiling limit, within the ceiling limit, board anyway has to take a decision and special resolution. Harmonize both, apply both the sections. 181C. Everyone understood the point clearly? Yeah. So, whenever try to resolve the conflict, don't override one on another immediately. Try to resolve and apply both the sections. Now we have to apply both. If it is within the, sir, 1 rupee borrowing also require board approval. If it exceeds ceiling limit, if exceeded, special resolution required, and up to the ceiling one person has to take a decision or not. So whenever there is a conflict between both the sections, first try to resolve conflict, apply both. Sir, I can't apply both, sir. One is a prohibited, one is a restrictive section. Then specific will override general. Did you understand harmonious construction clearly, everyone? Understood? So this is what we need to understand from harmonious construction. It's very important. Yeah, big rule, but very important rule for the exams. Okay. Take a breakfast break and come. We will complete remaining interpretation in 1 hour. Then I will go into FEMA. Okay. Take a breakfast break and come. 9:30, 10 o'clock we will reassemble. Again, I am telling live once completed. I will not post the video. This is only to have some discipline. Maybe at a later point of time I may upload. But if I say I upload, I know how students will be. So therefore, please take it very seriously. Complete in live. PDF I will send. Once it is completed, share capital interpretation, all PDFs I will put in the Telegram group directly. No need to purchase anything. Shall we continue? So let us start. So before we go to the next one, everyone confirm, did you all really understood the concept of harmonious construction fully? No mistakes are expected after listening to the session. Everyone got a full clarity. Yeah. Done. So next concept. Next one. Marginal notes. What is the next one? Marginal notes. Okay. First, let us understand what is this concept of marginal notes. Everyone, I need full concentration. Please, everyone. Everyone present live. Join fast. Still the number is increasing. Okay. Still joining fast. Okay. Now listen. Now we are going into the next concept called as marginal notes. Sir, what is this marginal notes? See, long back when the Bayer Acts were made, okay, when the Bayer Acts were made, see, if this is a page of the Bayer Act, Parliament made Bayer Act, okay, what they will do is, for example, I will show you the Bayer Act. See, let us see a Bayer Act section 179. What they have given? Powers of the board. What is this? Powers of the board. What we call this? This is called as title of a section. Okay, this is called as title of a section. Once upon a time, until 1990s, 1980s time, whenever the Parliament used to release the Bayer Act, okay, Parliament used to release the Bayer Act, they do not use it to keep the title like this. They used to write in the left hand or right hand side of the margins. Okay, they used to write either on the left hand side or on the right hand side of the margin. Means what? This is a page. Page, this is the left margin. This is a right margin. They used to write either in this left margin or in this right margin. Okay, this is what they used to do. Okay, they called it as marginal notes because they are in the margins. Because they are in the margins, they used to call it marginal notes. What is a marginal note? Marginal note or a title of a section summarizes the concept of a section. Summarizes the concept used in a section. What do you mean by summarizes concept used in the section? See, there are 4 subsections. Subsection 1, subsection 2, subsection 3, subsection 4. There are so many provisos. There are so many explanations. There are so many subclauses. All this put together, I wanted to tell in one name. What is it? Powers of the board. What is it? Yeah? Powers of the board. So, marginal notes or title of the section is the entire summary of the whole section. Entire summary of the whole section. But you should not tell that everything used in the section should be related to the powers of the board. Mainly the context is relating to the powers of the board. Okay. Powers of the board is the summary of the entire section. It is the identity of the entire section. If entire section have 100 things, subjectively, substantially, main thing is covered through the powers of the board. Are you understanding the point or not? Therefore, what they used to tell, main context is relating to powers of the board. This is not for interpretation. This is for summarizing the whole value of a section. Are you understanding the point or not? So the entire crux of a section, if I have to tell in one line, that will be called as powers of the board. Clear? See, there are two brothers, brother 1 and brother 2. Okay, these two brothers belong into one kingdom. Okay, these two brothers belong to one kingdom. They started disputing for one girl. Okay, kingdom dispute started, fight happened. Okay, and in the meanwhile there is another war sequence that has happened. If all these things in a very big story of 2.5 hours, if I have to put in one name, what people call it? People call it Bahubali. Are you understanding the point or not? Means what is the logic here? Bahubali means if I open the movie, everything should be in relation to Bahubali. Yeah? Some sequences will be there with him, some sequences will be there without him. Are you understanding the point or not? Some sequences will be there with him, some sequences will be there without him, some sequences like he is not there. Then why you named it Bahubali? Bahubali is not really there in this sequence. Subjectively, the substance of the whole movie is rotating around him. Same. Title of a movie is always taken from the substantial subject of that movie. Like that, title of a section or marginal notes is carrying on the subject of the entire section. Understood the point or not? Therefore, try to understand clearly. The idea is to summarize the whole idea and content of the section. It's not to do any interpretation. So, marginal notes. There are so many controversies on this. Okay, court controversy. Some will tell that no, marginal notes can be used for interpretation. Some will tell that are fool, marginal notes is not for interpretation, it is to summarize the content. But the general principle where courts are following is marginal notes cannot be taken to interpret a section. It is only to summarize the whole idea of the section. Everybody please answer, understood the point clearly or not? Okay, so the idea is not to interpret or construct the section. It is to summarize the value of a section. Okay, but Constitution of India is there, na? In Constitution of India, sections will not be there. Articles will be there. So the articles, a summary they will write in the margins. That can be used for interpretation. So in Constitution of India, when you are reading the articles, marginal notes also can be used for interpretation. But in all other acts of parliament, you cannot use marginal notes as a mode of construction. See now. See the answer given by the institute. Although there is a difference of opinion regarding resort to marginal notes for constructing an enactment, the generally held view, from here you need to start writing in the exam. A generally held principle or a view is that marginal notes appended to a section cannot be used for construing the section. Cannot be used for construing the section. In CIT versus Ahmed Bhai, Umar Bhai and company. Okay, next Patanjali Sastri J had declared, Patanjali Sastri is the judge, had declared that marginal notes in an Indian statute means in the act of a parliament, cannot be referred to for the purposes of construing the statute. And the same view has been taken in many other cases. Many cases show that reference to marginal notes may be permissible in exceptional cases for construing the section in a statute. Means exceptional 100 cases la 1 case la maybe marginal notes can be used for interpreting the section, but in most of the cases, it cannot be used for construing a section that was given in so many cases. Marginal notes in an Indian statute, that means in the Act of a Parliament, cannot be referred for construing the statute. Construing means proper interpretation of. Okay, proper interpretation of statute. For that, you should never consider marginal notes. However, it is important for exam. Marginal notes appended to articles of the Constitution have been held to be a part of Constitution as passed by the Constituent Assembly and therefore have been used for construing the articles. So, whenever marginal notes are appended, appended means added. Whenever the marginal notes are appended to articles of the Constitution, it is held that they can be used for construing the articles. But normal act of a parliament, if you wanted to pass that, you cannot use marginal notes for interpretation. Everybody please answer yes or no. Understood the marginal notes concept clearly or not? If you tell yes, I will move on to the next one. Okay. Next one. What is a title? What is a preamble? Okay. What is a title? What is a preamble? See, titles are of two types. Title 1, short title. Title 2, long title. Today, in the normal scenario, long title concept is not there. Short title is there. What is the short title? Name of the act is short title. Name of the act is short title. See, I will give you an example. Short title recognizes the enactment. I repeat, short title recognizes the enactment. See, what is this? The Companies Act 2013. What is this? The Income Tax Act 1961. What is this? This is the Goods and Services Tax Act 2017. That's it. It merely recognizes it. Who? Short title. Short title will just tell the name. Long title, rather than merely recognizing it, lightly it will describe also. Okay. Because of preamble coming into the act, which explains the purpose, lawmaker thought, why again we need long title? Short title and preamble is enough. Na? Preamble will tell purpose of the law, scope of the law, object of the law, for which it came, and evil it wanted to suppress. Sir, when I say evil dead la evil illa. Evil means bad. Okay. So, always why preamble? Preamble is inserted in the act in order to provide. Preamble is inserted in the act in order to tell the purpose of the act, object of the act, scope of the act. Okay, why it came, what is the purpose, what is the scope for which it is applicable. To tell that preamble came. Preamble is bigger than long title, so preamble is not a long title. Once upon a time, acts that are made in 1990s time, three things used to be there: short title, long title, preamble. Short title will merely recognize as an act. Long title not just merely recognizes, it give a light description. Preamble will give full description of the law. Why three things? Cinema story. First tell the name, next tell the gist, next tell scene on scene screenplay. This is not a movie. Na? Lawmaker thought that two things are enough. Number one, short title. Number two, preamble. Title. The enactment would have what is known as short title. Means the enactment is called as short title. The Companies Act, short title. That's why if you see the Bear Act, don't forget basics. Yeah, how many times I will tell? Short title. This act may be called as Companies Act. Don't forget basics. An enactment would have what is known as short title, long title. Okay. So enactment can be called in two names: short title, long title. Long title, what short title will do? Short title merely identify the enactment, recognizes it. Okay. Next, long title describes the enactment and not just identify. Short title recognizes, identify. Yes, this is Companies Act. Long title give a little description to that. Okay. Long title is a part of the act, and therefore recognize and therefore can be referred for ascertaining object and scope of the act. But today's scenario, long titles are removed. Why? Hero came. Preamble expresses the scope, objective of the act more comprehensively than long title. Then why long title? Short title say what is the act. It will identify what is the act. Mere identification will be done by short title. Long title give a little description. Why again long title when preamble already giving the scope, purpose, objective? So more comprehensively than long title. Preamble may recite, tell the ground and the cause for making a statute. Why you are making it will tell. Evil it wanted to remedy. Evil here represents bad. What unwanted practices are going on, what it wanted to stop. They will tell in the preamble. Preamble like a long title. That's why preamble like a long title. Preamble is like a long title. Can legitimately use it for construing. However, preamble cannot override the provisions of the act. Same. Sir, there are 470 sections in Companies Act. There are 470 sections in Companies Act. Preamble can be hardly one line. In that one line, what I will do, I will summarize the entire purpose of the act. Every section you should not see like this. See, point number 1. Do you understand the point? See, point number 1. What is the section? This section is talking about, for example, prohibited associations. What is the preamble? To incorporate companies, to incorporate, regulate, and form the companies. Where is the link between prohibited associations and this one? Therefore, this section is outside the preamble. Like that, we should not tell. Preamble also is like summary of the entire act. It's a description to the entire act. Therefore, try to just to use the preamble to understand the whole idea of what is a preamble. But do not always check on section basis. Every section should match with the preamble. No section will match like that. Preamble hardly is a one-line answer. Okay, 470 sections are there. How come each and every section will match with that? Understood? Huh? For example, if I write preamble, incorporate, regulate, and wind up companies. Incorporate, regulate, wind up companies is the object of Companies Act. Say for example, okay, investigation is there. Where is investigation here? In preamble. Therefore, investigation chapter is wrong. Like that, we should not tell. Regulation, all these things will come. Understood or not? So each and every section you should not compare with preamble. Preamble is for overall understanding. Understood the point? So preamble will give purpose or scope and objective of an act more comprehensively than long title. Preamble will recite two things: ground and cause for which it came, and evil it wanted to remedy. Next, it can be used for construing the law. Construing means interpretation of law. Preamble cannot override the plain provisions of the act. Only if the wording of the act gives rise to the doubts as to the proper construction, the preamble can and ought to be referred to arrive at a proper construction. Easy way to remember, see here. Now you should tell whether you understood or not after reading this, not before. Then I will get doubts on you. Read long title and short title now from the notes I have written. I have written means I did not write anything, copied from ICA. Straight answer. Summarization I did, unnecessary points I removed wherever required. Short title will recognize the law identified. An enactment is called as a short title. A long title will not merely recognize, but it will describe the enactment. Long title will be a part of enactment once upon a time. Preamble. Preamble explains the object and scope and purpose of an act. Point 1. Preamble explains the object of an act more comprehensively than long title. Number 2. Preamble will express the cause of an act. Evil it wanted to provide a remedy. Next. Preamble cannot override the plain provision of law. However, when the provision gives rise to ambiguity, doubtfulness, okay, as to its proper interpretation, one may refer to preamble. First of all, everyone tell me, did you understand both the answers or not? One yes. Did you understand the whole answer or not, everyone? Okay. Next. Difference between interpretation and construction. Okay. Difference between interpretation and construction. Okay. 4 marks. 4 marks ki no one will write this much. Institute sized answers, another problem is there. Irrespective of the size of the question, marks, they will give the answer. What is required for exam? I will show you. Difference between interpretation and construction. See here. These are the 4 points you have to write for that 4 marks. Okay. Because we can't remember all those contents unnecessarily. So remember at least these 4 points. Okay. First, I will explain. Okay. I will explain. After that, you read. Okay. Before that, don't do unnecessary things. Interpretation means giving a right word to the right meaning to the words used. Right meaning to the words used. The concept of applying a right meaning to the words used in the law is called as interpretation. Okay, it is simple way of understanding. Okay, see, if you take a section called as buyback law, what it said, buyback can be made by a company out of the following sources: free reserves, securities premium, proceeds of any issue of shares or securities. Clarity. A company is defined already, can go for a buyback, means purchasing its own securities. Out of what sources? Free reserve, definition is there. Securities premium, definition is there. Giving the right meaning to the words used. Don't understand in the way you want. Understand in the way lawmaker want you to learn. In that way, if you give anything, I call it interpretation. Generally, people think interpretation, construction, both are same. But no. Interpretation is a concept of giving right meaning, correct meaning to the words and terms used. Number 1. Whereas construction is traveling beyond the words of law. Traveling beyond the words of law. Sometimes giving the words used a direct meaning will not give a proper result. Street Offenders Act example, classic example. Means when you apply Street Offenders Act street to include only a street, then people will start harassing in different places other than street. Then you yourself is encouraging the harassment. That means you are asking them, don't do here, go and do there. Understood the point or not? Understood? Okay. So try to understand. You went to you wanted to go to a shopping mall. Okay. Outside the shopping mall, there is a very big compound wall. Okay. Very big compound wall. Shopping mall compound wall is there. Huge traffic will be there in that road. Classic example, shall I tell you? Whenever I go to Roypeta Express Avenue Mall, Chennai la Express Avenue Mall irukana. So yeah, Roypeta Express Avenue Mall opposite there will be a compound. After the compound wall, clearly they will put, don't park here or do not park here. They will put a no parking board. Am I clear? See now. They kept no parking. They kept a board. Okay. I will park my bike here. I will park my bike here. I said, no parking here. Na? So in this area, I will not park. Now tell me, is this a right interpretation? Opposite to that board, I will not. Left to right, I will do. Do you understand what I said, everyone? No parking means what? You should understand that with common sense, certain times, giving a plain meaning, no parking here, means not here, anywhere here. Understood the point or not? Like that lawmaker also, when I use the word street, street means don't literally take on the road. Anything belonging to the street. Understood? That's called as a construction. That's called as what? Construction. Okay. I used to give one example in the class. Okay. I used to give one example in the class. What I used to tell, there is one case law that happened in Companies Act 1956. Okay. Companies Act 1956. That case law I will tell when we come to contemporaneous expositio. That's why I'm holding that example. Okay. When we come there, I will only explain. That's why I'm not telling anything. I will tell that example at a later stage. So let us first try to understand clearly one point. Point number 1. Interpretation construction. Let us understand the meanings. Interpretation is a process by which courts will ascertain the meaning of the legislature through the medium of the words. Read. Interpretation is a process by which courts will ascertain the meaning of the legislature, meaning of the lawmaker, through the medium of the words. Means what? Giving meaning to the words used. Literally interpreting is called as interpretation. In simple terms, it is a process of giving real meaning to the words and ascertaining the intention of the legislature. When I use the word securities premium, you don't apply your meaning, you apply the real meaning. There is a definition in Companies Act for securities premium. There is a definition for free reserve. Give that real meaning and understand the intention of the lawmaker. Okay, through the medium of the words. In interpretation, words are given importance. Street means only street. Buildings will not come. This is called as interpretation. But what is construction? Construction is a process of ascertaining the true meaning and intention of the framers, that is the lawmaker. So I will not give the importance to the words. I will give importance to the meaning inside that and the intention of the lawmaker, even though sometimes it may deviate the text of law. Lawmaker might have written street. I will also include buildings in that. It's a Street Offenders Act, not Building Offenders Act. Street will include buildings also. This is construction. This is not interpretation. Street means really it's a street only. Are you understanding or not? Building has separate building number. Street has a street number. But to protect that law, court said that street includes a building there. Construction is a process of ascertaining the true meaning. Ascertaining true meaning or intention of the framers. It is a concept of going beyond the actual expression. Very important. Going beyond the actual expression means street is an expression. Street means literally a road only, technically speaking. Correct or not? Now, but I will travel, I will go beyond the actual expression. But I don't want it to take it as a street. Street also includes all buildings inside the street. Do you understand the difference between interpretation and construction or not, everyone? Reply. Reply, everyone understood? So, sometimes give importance to the medium of the words. Lawmaker wanted to tell something, he will tell by medium of the words. Follow that. Interpretation. Giving right meaning and intention. Interpretation. Going beyond the meaning, going beyond the words, going beyond the text and giving a meaning which lawmaker intended to give, though it is not as per the text of law. Construction. Understood the point clearly? Yeah. So this is what you have to understand. Next. So that's why. For that we need not read all these things. Next. See. Mandatory provision, directory provision. What is a mandatory provision? What is a directory provision? See, this also I have a notes. Please listen carefully. All important contents I kept the notes with me. What is a mandatory? Just a minute. Yeah? Okay. See here now. See here. Interpretation of may and shall. Interpretation of may and shall. Okay. Let us understand how to understand may and shall. May is a directory provision. Shall is a mandatory provision. Again I repeat. May is a directory provision. Shall is a mandatory provision. What is the difference between may and shall? May is a directory provision. What do you mean by directory provision? Directory provision means you may do, you may not do. You may do, you may not do. Even if you don't do, nothing will happen. That's called as a may provision, also called as a directory provision. I repeat, may is a directory in nature, shall is mandatory in nature. 2 points. Okay, so see, there is a section. That section said that you must do this action or you must act on this without any option, without any discretion. I repeat, without any option, without any discretion. Discretion means I will think and decide. No, I will not give that chance. I may or may not do. No, I will not give you that option. No option, no discretion. Without any option, without any discretion, you must to do that. That's called as mandatory provision. Generally, mandatory provision will carry shall with it. Next, where the person acting is having authority as well as option to do it. Means what? Police have a power to arrest, but not always. I can exercise that power when required. That's called as a may. A police shall arrest illa, may arrest, may detain, not shall detain. Understood the point? So sometimes my action have both authority and option. Sometimes my action is not having any option or discretion. Must to do. Always, whenever I have authority and option, lawmaker is said to be, that section said to be directory in nature, associated with the terms may. Read up to here first. Tell me whether you understood what I said or not after reading 4 points. Have you read? Everyone, have you read? Okay. Next, 4 points you completed. See, next one. May signifies permission and authority. Okay, signifies permission and authority is having a discretion. On the other hand, shall is a word of command. Shall is a word of command. Means what? You must do. That's all. It's a command. Okay. May signifies a permission. That means you gave me a permit. I may come, may not come. Understood the point? For example, I have a license to drive a vehicle. I have a license means what? I have a permit to take my vehicle. That does not mean I must drive a vehicle now because of the reason that I have a license. License is a may provision. License is a may provision. Wearing a helmet is a shall provision. It's a command. You must do. Okay. Driving a vehicle is an option to you. But once you drive, wearing helmet is a shall command. Now, did you understand the point or not? Understood? Having license is a permission given to you. You may either exercise, you may not exercise. But once you exercise, wearing a helmet in a bike, on a bike, wearing a seat belt in the car, both are shall commands. Everyone understood? Okay. Next. In case where normal significance and interpretation as permissible gives rise to absurdity. And normally if you give may meaning, shall meaning, may directory, shall mandatory, may discretion, shall command. If you give this meaning, sometimes it may lead to wrong results. When I will explain later. In such case, it shall be disregarded. Sometimes, though may is permissive and directory, it shall be read as if it is mandatory and therefore it shall be read as shall. Means sometimes may, which is directory in nature, should be treated as if it is mandatory in nature and will be read as a shall. Though it is M-A-Y is called as what? Shall. Sir, no sir, M-A-Y, it's may. No, M-A-Y, shall. Understood? So what is the meaning here? My intention is, though the lawmaker use the word may, you will read it as if it is shall for some purposes. What are that? Next point, we will read all those. Up to here, I think everyone understood the point clearly. Let us see. Next. So, next. Grammatical interpretation, already we read. Important ones I am discussing. Let us see proviso. So, this concept is very important here, not just asked in one RTP. This came in one of the recent attempts also. What concept? Meaning of a proviso. Okay. Not just the meaning of a proviso, they will ask a difference between proviso, exception, and a saving clause. Proviso, exception, and a saving clause. See, I have a notes. I have a notes also on this. See here. Proviso is used for two purposes. Okay. To create an exception, to qualify things stated in enactment. I will make it faster. Create an exception means section is saying something. Proviso will tell that these are not applicable for that provision. I didn't understand. Sorry, I will give an example. See here. They will tell like this. Every company must conduct 4 board meetings every year. Okay, 4 board meetings every year. Provided that Section 8 company need not conduct. Means what? Generally provisional 4 meetings. But Section 8 company that is not applicable. That is given in the form of a proviso. Proviso can be used to create an exception. Or it can create new condition. That's called as qualify. Qualify means what? Adding new points. Section is saying something. Qualification will add new points to that. Okay. I will give an example. I will tell this way. Auditor will be appointed by board of directors in a general meeting. Shareholders in a general meeting. I said this. Provided that ADT 1 has to be filed with ROC within 30 days of appointment. Now what is this? Normally the provision said that shareholders in a general meeting will appoint or ratify the appointment of auditor. You should file ADT 1 within 30 days. What does it mean? This proviso is an additional condition after appointed. So this is not an exception, this is a qualification. Everyone repeat. Understood the point clearly or not? Fast. We don't have time. Have to complete very fast. I think this notes is available on Telegram. If not there, I will share. Okay. You need not worry. No need to buy anything. Okay. Okay. Done. So now listen. Proviso is embedded within the section, means it is a part of a section, it is an integral part. Section below it will be there, it is not somewhere outside the section. Okay, how to identify that there is a proviso? Provided that. But the most important discussion we are going to make today, which will definitely bring a change in your understanding. Difference between exception, proviso, saving clause. Sir, proviso creates exception, sir? No. Proviso creates exception, but directly there can be an exception. How is it, sir? Let us read. Exception, proviso, saving clause. Exception. Exceptions are intended to restrain any provision to a particular case. Proviso is used to remove special cases from a general enactment. Saving clause preserves from destruction of certain rights, privileges, etc. Sir, one word also I did not understand. That's why I am here now. Read first. Put your efforts. Read properly. Read 3-4 times. Till you understand, you read. Have you read? Have you read? If you say yes, we will go into analysis. Okay, na? Now, can anyone in the live? Okay, can anyone in the live? Do you know? And can you tell me any example of an exception you saw in Companies Act? We should appreciate that student here. Okay, every one of us should clap for him if we tell a right answer. If you give a right answer for this, really a huge applause to him. Tell me an example where you found exception in Companies Act. Exception I asked. Don't give other answers. Section 96, sir. What is there? Correct. One person has given right answer. Pavan Krishna. Super. Yes. Yes, another one, Ash Gamer. He also have given a right answer. Yes. Super. Yes, general meeting for OPC again, super. See, like this, so many exceptions are there. Na? See, I will give a classic example. You need not even go up to there and break your head. Simple example. Okay, private limited company definition of what they say. Private limited company means a company which a company which is having a minimum paid up share capital and by its articles restrict the transfer of share limits except in case of one person company. Except in case of one person company. Except in case of one person. Already section is bringing it outside the purview of the section. Exceptions are intended to restrain, means prohibit completely on a particular case. In this discussion, don't bring them. Okay, that is exception. Like what others also said. Very good, very good. Good participation. Next, proviso. Proviso is not excluding it. They are saying that normally you have to conduct 4 board meetings. Okay, meetings are applicable for Section 8 company. 4 board meeting concepts are not applicable. Instead of 4, you have to conduct only 2. Like that, proviso is used to remove special cases from the general cases. Understood the point or not? It wanted to remove special cases from the general cases. Okay. So, very good. Everyone has given a right answer. Super. So, next. Sir, everyone tell me, did you understand proviso and exception? Exception totally not applicable. Proviso, general provision they will give. To whom this general provision do not apply, they will give in proviso. Okay, done. Next one, what is a saving clause? What is a saving clause? See, this I have to tell. Saving clause is a part of harmonious construction. Everyone, saving clause is a part of harmonious construction. How to identify that there is a saving clause? Save as otherwise provided. Save as expressly provided. Save as if you see the words. Whenever the word save as comes, it is called as saving clause. It is called as what clause? Saving clause. What do you mean by a saving clause exactly? What does it exactly mean to say? Listen. Saving clauses are meant to preserve. They are meant to preserve from the destruction of certain rights and privileges. See, I will write like this. Save as otherwise provided. This is the rule. Something I have said. Means what? This rule will normally apply. However, if otherwise provided, otherwise represents differently. If otherwise provided, please follow that. Please follow that. Sir, give an example. Section 6, I used to tell in the class always. Those who attended regular classes, you know this example. Act to override memorandum articles, etc. Okay. Save as otherwise expressly provided in this act. Save as otherwise expressly provided in this act. Okay. The provisions of this act, something they said. So what is the whole idea? Idea is very clear. Save as otherwise expressly provided in this act. Act will override memorandum and articles. Means act is always greater than MOA, greater than AOA. It is general rule. Okay. Some sections are there where rights and privileges are given. Rights and privileges are given where this rule is differently provided. Classic example, additional director appointment. Which director appointment? Additional director appointment. Or, sir, additional director not in our syllabus, no, sir. Please give me one example from my syllabus, sir. Buyback, sir. Buyback. Buyback law, what is there? Buyback must be authorized by articles. Sir, another example, sir. Yesterday only we read, sir. Concept of differential voting rights. Articles must provide. From that, what you understand? Buyback cannot be made if articles of association is not providing for buyback. Means section 68 do not apply unless article says something. Means whether to apply or not to apply 68 depends on whom? AOA. And act is dependent on AOA here. Correct or not? Means the right, the privilege of going to buyback is dependent on articles, not on act. So therefore, lawmakers say to preserve that section, in some sections they use the word save as otherwise provided. Means general rule is what is provided in the section. But otherwise, in any other provision, if there is a differently provided, follow that, not this. Do you understand the example and content what I explained now? Everybody in the class. Okay. Hey, 1 minute here. Power cut. Just a minute. It will switch off. Wait. Inverter on in there. ఎంతసేపు ఉంది బ్యాకప్ ఎక్కడుంది అదంతసేపు ఇవ్వదుగా బ్యాకప్ చూడు ఒకసారి ఆల్టర్నేటివ్ చూడు త్వరగా చూడు ఓకే సో చూడు తొందరగా చూడు పవర్ కట్ యా if class stops all of a sudden don't worry power cut okay I will continue till that inverter switch off clear if in the meanwhile power comes on very good or else don't worry no problem even if anything is missed extra session also we will take and we will complete I will not leave you okay with the same clarity we will read no worry no compromise in that next this is actually from General Clauses Act I will discuss in GCA these two Heydon's rule already we completed grammatical interpretation first one we completed proviso we already completed see remaining all are repeated means includes so whenever the term means is used in the act only that has to come includes means it is extensive you can add so many things into that means and includes definition of a word expression in the definition may be either be restricting of its ordinary meaning or can be extensive if it is restrictive definition means if it is extensive definition includes when a word defined to mean such and such the word prima facie is restrictive and exhaustive okay so next but where the word is defined to include the definition prima facie is extensive here the word defined is not restricted to the meaning assigned but it has to be extensive which also includes the meaning assigned that's why always I tell means always represents restricted and exhaustive includes always represents okay extensive and broader sense we need to interpret see here Now what I will do is, remaining whatever the interpretation rules are there, first let me cover those and complete in the meanwhile, before this power goes away. Because anyway, wherever the topic you see, that's what I said. Interpretation of statutes chapter, the greatest advantage is what is there in the subject, directly they will ask questions, no twisting. So learn properly, 10 to 13 marks pakka. Okay? Let's see. Rule of literal construction. Rule of literal construction. Whatever exam questions are given, 16, 17 exam questions we have done. Now I will do other questions which are not tested. Somewhere else it will be there 1 or 2 times. But let us complete. What is a literal construction? Are you all with me? Let us move fast and complete this first. Everyone, are you all with me? Shall we begin? Yeah. So little rush because before it switch off, we need to complete the chapter first. Okay. Focus, focus, please. Concentrate properly. I will cover each and every concept. I am not going to leave any concept for you. I will cover every point. Okay. See, rule of literal construction. The first and primary rule of construction is that intention of the law should be understood from the words of law itself. What I said from the literal construction from the very beginning, whenever the words are used, give literal meaning to that. Understand it in a normal sense. Okay. So first and primary rule is intention of the law must be understood from the words directly. Whatever the words they use, interpret them in a proper way and understand it in a right way. That's it. Your job is done. This is one. Next. If the words of law are capable of giving only one meaning, when you read, yes, it's giving only one meaning. What free resource is there? What meaning you will give? Already there is a definition for that. How come you give a double meaning or triple meaning to that? There is only one meaning. So if the words of law are capable of giving only one meaning, then it is not open to the court also. Means Supreme Court of India also cannot ignore its plain meaning, adopt a hypothetical construction. Means when the words of law are capable of only one interpretation, one meaning only, even courts also cannot go for hypothetical construction. So what are the first two? The first and primary rule is intention of the law should be understood from the words of law itself. If the language is plain, capable of only one and only one meaning, then court is also not allowed to go for a hypothetical construction by ignoring its literal meaning. Next, the cardinal rule, that means the most important rule is that statute has to be read literally with its natural and grammatical. If you remember, we read one point called as a grammatical interpretation. Means what? Meaning of the law should be understood in its natural, popular, and ordinary meaning, and should be construed in plain, literal, and ordinary sense. You have to understand the grammatical meaning has to be given. NPOPLG you have written natural, popular, ordinary meaning, and construe it in a that's it. The literal and the plain, and you have to give the plain, literal, and grammatical meaning. If you remember, we have already done that in a previous point. So the cardinal rule is that understand the law literally and natural and grammatical meaning you have to assign. If the meaning is plain, then it is not desirable to make reference to cases. What I said, when the meaning is very clear in the law itself, then don't go to court case laws. Court case laws, when you have to go, when a meaning is not defined in the act and dictionary versus court come, go to the court decisions. When already defined, why you are going to court or action? Next, if the language used in the statute is clear and unambiguous, ambiguous means unclear, unambiguous means absolutely clear, and it is capable of only one interpretation, it is not correct to move out of its natural and ordinary meaning. Where there is a choice to make between two interpretations, for example, there is a word, you have a choice whether to give a strict meaning or to give a wider meaning. Go for a wider meaning which serves the purpose of that section. Okay, adopt the wider one. Mainly 1, 2, 3, 4, 5. These 5 points you should not forget in the exam. First and primary rule is that intention of the law should be understood from the words. Words of law are capable of giving only one meaning. Then please, court also cannot go for hypothetical construction. The most important rule is understand the law literally in its natural and grammatical meaning. If the meaning is plain, it is not desirable to go for case laws. If the language is clear and unambiguous, then it and capable of only giving one interpretation, okay, it is not correct to move out of its natural and ordinary meaning. It is not correct to move out of natural and ordinary meaning. When there is a choice to make between two interpretations, one is a narrow interpretation, one is a broader interpretation, okay, and a narrow interpretation fails to achieve the purpose, then they should go for a wider one. Then only we discuss these points. Okay, next. First of all, everyone tell me, did you all understand literal construction concept clearly? Very important. Yeah, 6-7 times it was tested in exam already. Understood literal construction? Yeah. Next. Ejusdem generis. Let us go into it. These all are simple only. Let us go to Ejusdem generis. See, simple rule here. This is 5 minutes will complete. Ejusdem generis rule says that, okay, Ejusdem generis, the rule of Ejusdem generis says that there should be enumeration of specific words. Okay, there should be enumeration of specific words. Specific words are followed by general words. Means general words are following specific words. First, specific words. General word is following the specific words. These specific words fall under one category. Okay, and the whole category is not exhausted, and there is no other legislative intention. Then the general words will take the meaning from the previous specific words. Sir, I did not understand. See, I will tell like this. I will tell this way. While reading a section, we said directors, KMP, etc. In this etc., director is a specific term. KMP is a specific term. These are all high level management. Okay, etc. Etc. means it's a general term. Specific terms fall under one category called as what? Management. High level management. In this high level management, only directors and KMP, others also will be there. Others also will be there. So there is a chance to insert many things into this etc. Okay, so it should not exhaust the whole category. Already I said director, managing director, whole time director, manager, CEO, CFO, like that. If I say everything, then already you are only telling everything. Then where is the concept of etc.? Or for example, I said directors, etc. Etc. means those who belong to director's cadre, that range, those only should come. So therefore, director is a specific word, etc. is a general word. Specific word is belonging to a category. Okay. Next, this general word should take the meaning from previous specific words. Should take the meaning from previous specific words. Understood the point clearly? Yeah. Understood the point clearly. So the general term etc. should take the meaning from previous. In this, watchman, normal employee will not come. Why? The etc. should take its meaning from the previous specific words, not in the way you wanted to take. Understood the point clearly? Everybody? So there must be enumeration of specific words, directors, etc. General word should follow a specific word, etc. Specific word fall under one category, high level management. Specific word do not exhaust means complete the whole category. Not only director, so many other people are also there. So etc. has a meaning. And there is no other alternative intent. Means lawmaker don't want it to include some people, means they will tell clearly there. Nothing is said. Directors, etc. Means etc. should include only those people included into that. Next. Non-applicability of the rule. When this ejusdem generis does not apply, if the enumeration itself contains general words. I said employee, shareholder, director, etc. Employee means person working in employment. Shareholder means person who invested in shares. Directors means appointed in management. All are three general words. Those are not specific words. Then rule does not apply. Or I said clearly, first director, section 160 director, rotational director, non-rotational director, women director, Indian national director, independent director, okay, small shareholder director, additional director, alternate director, nominee director, next casual vacancy director, directors appointed by the principle of proportional representation, tribunal appointed director, managing director, whole-time director, manager being a director, CEO, CFO, CES, officer, etc. EM, etc. All are completed. EM, etc. Everything is completed. Na? Your specific words are exhausting the entire category. Then what is the meaning of that etc., etc., so on, others? There is no room because already you only completed the entire list. If there is a 20, 30 in the list, you said 2, 3, then etc. has a meaning. You only said everything. Where is the chance of etc.? So the specific word should not exhaust the whole category. If it exhausts that, it will not apply. Where the law intends not to use ejusdem generis. Where the law intends not to use ejusdem generis. Means what? Generally, ejusdem generis will come. But lawmaker said that etc. include these. The lawmaker said etc. include these. When I myself said etc. include these, why you are including others other than that? So then the rule does not apply. Okay? Okay. So there should be specific word. General word follows specific word. Specific word falls under a category. They do not exhaust whole category. There is no other alternative intent. In that case, what will happen? General words shall take their meaning from previous specific words. Everybody answer. Understood the point clearly? Everyone? Next, nos iter asocis. What is this? Nos iter asocis. What is nos iter asocis? See, it is similar to ejusdem generis, but not completely. Ejusdem generis, what will happen? Specific words, general words follow specific words. Nos iter asocis are not like that. All are specific words, say, but the specific word has 2, 3 meanings. Okay, see, I said my bag containing toothpaste, toothbrush, towel, and oil is missing. Okay, here you should observe oil is not a general term, it's a technical term only, it's a specific word only. But this specific word has multiple meanings now. Oil, grease oil, petroleum oil, okay, grease oil, petroleum oil, or edible oil, hair oil. There are so many meanings, na? Toothpaste, toothbrush, towel, and oil. This oil has multiple meanings. In this multiple, which one you will apply? Grease oil, petroleum oil, edible oil, hair oil. Everyone reply. That's called as nos iter asocis. We include hair oil into it because I am using that oil in relation to human consumption on the body, not inside the body. Understood the point or not, everyone? So, when 2 or more words are susceptible, means subjected to, analogous of each other, means same like each other, then they must be understood in their cognate sense, in their correct sense. The general word shall take its color from previous words. Here, oil, though specific, now it became general because there are 2, 3 meanings given to that. Which meaning you should take? Previous words. From there you should take the definition. So this you read, this attempt, this and this has a chance. 4 marks you can expect. Literally mug up these two. You should understand and write in the same way in exam. Contemporanea expositio. Okay, contemporanea expositio. See, whenever people say any rule, any section, long back act will be made. You will be reading 20, 30 years after making of law. At that time, on the basis of, it is about to switch off. Let's complete. At that time, on the basis of the prevailing circumstances, they made that law. They made that section. When you are reading in the current scenario, sometimes reading from that point of view may not be right. See, a law which is made in 1956, at that time fax machine is not there. Okay, a law which is made in 1956. This example everyone know. I told in regular classes so many times. Okay, so there is one case law called as a J. Manjiram versus Ferricios. In that case law, this has happened. 1956 law, an act was made. At the time, fax machine is not there. Okay. So, at that time when the law was made, they written board meeting notice must be sent only by hand delivery or by post. What does it mean? Either you should send by hand delivery or by post. No other means. 1993 la fax machines came, but the law does not include fax. A company sent the notice of a board meeting by fax. Other person said this is invalid. Matter went to the court. Court said that use contemporaneous expositio concept. Exposition means past. Contemporary means present. Okay. The law was made in exposition. 1946 law was made. You are reading in 1993. Read from today's context. In today's scenario, if law is law is made in 1993, they would have included fax or not? Yes. Or if a fax is there in 1956 itself, they might have included fax or not? Yes. Therefore, though section of fax is not there, that's what I said about construction and interpretation difference. Interpretation give importance to the words. Construction go beyond the words. Actually, post and hand delivery only allowed. But court included fax also into this. Means what? This is newly constructed term. That's why we call it construction rules, not interpretation rules. Contemporaneous expositio says that old provision, sometimes we should not, sometimes not all the times. Sometimes we should not read from the old point of view. We should read from the today's point of view. Okay. So though section of fax is not there, fax is a means of communication of board meeting notice. Everybody answer understood the concept of contemporaneous expositio or not? Everyone. Okay. Next. Heydon's rule already completed. This is another expected question for your examination. Golden rule of interpretation, also called as reasonable construction. What is reasonable? Reasonable, harmonious, beneficial, all these will come. See, generally the words of statute should be understood in its sensible meaning. Already we read this point. It is only when there is a scope of two or more interpretation, construction comes in place. Means one word, 2-3 meanings are coming. Then go for construction. So that interpretation which furthers the object, furthers means which increases, okay, which increases the object of the act or which will make it successful, that's called as a furthering. Furthering represents make it more meaningful, like that you can understand. So that interpretation which furthers the object of the act should be preferred over which defeats it. Similarly, when grammatical interpretation is leading to absurdity, court will resort to reasonable construction. Okay. If court finds that giving a plain meaning is not fair and reasonable, is not fair and not reasonable, it becomes duty of the court to depart from the dictionary meaning and adopt such a construction which suppress the mischief and advance a remedy. Sir, this is just nothing but combination of all rules we read till now. Correct or not, everyone? Simply, whenever literal construction fails, reasonable comes in place. In reasonable, again, different things are there. Exceptional. Just now we read, may should be read as shall, end should be read as or, those things. Easy concept. Just Notes, if you read, you can understand. Harmonious already we completed. So these are all the various concepts which we need to read, okay, from this particular area called as interpretation of statutes. Okay, it is not just going to die in another 2-3 minutes. So if it comes immediately, we will have a live immediately, or else tomorrow I will continue the session. Okay, if not, extra one day also I am ready to take. But let us complete this 60 marks of our syllabus in our revision itself. Clear, everyone? Hello, I am talking to you. Sir, first everyone please put one message. Okay, are you all really feeling that these sessions are helpful to you? Could you revise and complete the concepts in the revision class itself? Are you confident about this 10 or 14 marks? Very good, very good. See, next we are coming with FM. At the very level, I prepared everything, not normal level. Okay, because after seeing the AFM result at CA final, because every attempt I used to get huge result for CA final AFM. But after the last result, now when even north side or any other place, people could not crack 90 plus. Many students, around 6 students of me has got more than 90 is the greatest motivation. Means the path what I chosen is 100% right. The way in which I am taking AFM is 1000% right. 100 stones people might throw. Okay, so why you are explaining the derivation, why you are explaining a formula, why you are explaining the meaning behind the formula, just to do the formula, get the answer. Or it is easy to copy people. Na? If I tell something, some formula derivation, one person will take, read the video, see, do the answer. It's very easy to copy. But to create it is extremely difficult. So, same we are also planning for CA Inter FM to increase the result percentage of the students. So good amount of efforts we will put this time in the revision as well for FM. So inform all your friends as well. Okay. So after the CA final AFM, the greatest motivation that I obtained is I should not change my path. I am going on a right track. My bare act study for law DT, my formula analysis, derivation of the formula, logic behind everything is a right path. Students are proving that I am right time and again. So I am very happy. Okay, so that means the way in which I am going, the route I chosen is always right path. So I never go by any kind of shortcut methods to understand anything. That's a right path. You will also travel in a right path. Read properly. Study material, don't leave. Simple logic, study material, don't leave. Okay, do this for DT. See, I will openly tell you DT exactly to tell. I don't have time now. Exactly, I don't have time because once I complete law revision, I need to start FM. After FM, I need to start AFM revision. Okay. What can I do is August month, last week of August. Before that, I can't do. Why to make false promises? Okay. So DT August last week until 22 like that. At that time, I will release DT revision regarding 30 marks portion I can do. PGBP, capital gain, other sources, I will do the revision. Okay, 30 marks I can do. PGBP, capital gains, other sources. These I can do, but remaining or house property I will do here. Remaining time is not there. Actual problem is time is not there. It is about to die. Key, it's making sound. That means telling me get lost from this room. Bye. TDS TCS will take one janma. If I start in this janma, na, next janma we will complete. You know about me. Bare line will take half an hour here. And marks will be 6 marks. Okay. Bye. It's shouting.